wish I could get my kids to listen that well. That's impressive. That's impressive. We'll now open the meeting. It is 8:35, and we'll call the meeting to order. And can we, Mr. Cass, will you open us in prayer?
Shall you?
Sorry. I'm sorry.
Thank you. Thank you so much. Dear Father, it's an honor for us to be here today. We thank you for the opportunity to work on your behalf and then in behalf of the agency and on behalf of the citizens of the state of Texas. Please instill in us the listening skills, the compassion to do your will and to serve in the manner in which we've been honored and have the privilege. In your name, thank you.
Okay, Tamla, can you call roll, please?
Chairman Rick Figueroa.
Here.
Vice Chairman Tom Butler. Dr. Ray Callis. Commissioner Helen Collier.
Here.
Commissioner Nora Castaneda. Commissioner Joel Garza.
Here.
Dr. Gary Wesson.
Here.
You have a quorum.
Can I have a motion to excuse absences of the other commissioners?
Yep. I move that we excuse the commissioners that are not here and absent today.
I'll second.
All in favor?
Aye.
All right, so the next thing is, Carla. You have 2 minutes. Make your comments quick. You can come over here. No, you got to come up in front of us. You got to get in the firing squad. You gotta get in the firing squad.
Did you sign in?
Any derogatory comments will be taken offensively. So, first of all, on behalf of TLR, you are an amazing employee, but an amazing friend and an amazing person as a whole, and we thank you so much for what you've done. It is an honor to serve with you. I've seen how hard you work, especially as a legislature. I think you held some people hostage, and, so I'm not going to ask questions because I don't want to be subpoenaed. So, you've done an amazing job, and sometimes an impossible job, and you've completed that. So thank you for that. I'm going to give you a few minutes, and then after that, we'd love to walk you over to that podium if you don't mind.
And if I may, before Carla gets started, you okay with that, Mr. Chairman? Thank you. I think right place, right time. You know, when Brian's bringing the ship up, and you were there solid. And that was cemented all the way, because that time that I saw you, literally when they were, I forget where it was in the legislature, what they were talking about, and you were out of the chair before, Brian had his seatbelt undone, right? You jumped up and running to go to make sure that they know that TDR was in the house. And there's a special passion for that. And so I appreciate, what you've done and what you brought to the table. And thank you for continuing to support her as well, because I know that you'll do that.
Thank you.
Thanks.
Any comments?
Oh, I've only been on a couple of years, but just when I got appointed, to see the level of talent that we have up at the top and how you performed in getting us through this legislative session, which was my first, was awesome, and just enjoyed working with you for the short time that I have, and wish you the best in retirement.
Thank you. I guess I should say my name, Carla James, TDLR. It has been a distinct honor to work for this agency. I have worked for a lot of agencies, and when I say a lot, I mean a lot. 7 in total in my 25 years.
Wow.
This is the best run agency that I've worked at, and I can say that I didn't work at ERS, so they'll still give me my annuity check next month. We have a group of folks here, and I said this at my retirement party last week, and I'm not going to cry this time because it was just a jag of crying. But we have a group of folks in this agency who are very unique to state government. I have worked with a lot of people, and you run across a fair amount who are very dedicated to Texans, dedicated to their jobs, somewhat dedicated to their agencies, because there's not reciprocity from the agency for that dedication. This place is different. I said that the day I started. I've known Brian many, many years. I've known Bill many, many years, and so I knew it was different when I came here. I wasn't even looking for a job when I found this job. I was looking for a friend of mine, and I knew which agencies were good and which agencies you didn't want to work for, and so I clicked on TDLR and saw this job. Whoa, I can do that. So I applied, not really understanding the full breadth of what I was coming into. this family environment, or I'll say a community environment now, because we are so large. And realized quickly what I walked into, which was, as I said, a group of really dedicated state employees. I shouldn't say state employees. I don't like that term. Public servants. Big difference. And I've been honored to help lead them. They understand what they do for Texans. We are not necessarily putting out fires and saving babies and all of that stuff, but we're keeping many, many Texans working so that they can provide for their families.
We do say babies, but go ahead.
Okay, well, and Helen says we say babies, maybe in the midwife area, but
Let her have her time.
let me start my speech over.
Start
No kidding.
over, 2 more minutes. 2 more minutes.
No, I don't need 2 more minutes.
Introduce the vice chair. Go ahead.
It's just been a distinct honor to work with these folks, very dedicated, understanding what they do for Texas. And I felt like I fit in because that's the way I've felt for 25 years. So I appreciate the love and goodwill I received when I got here, open arms from many of the staff, and literally open arms. I'll say one story and then I'll finish with a thanks. When I started, the first day I came in, I went up to the 10th floor of EOT and everybody hugged me. And I thought, how nice is that? I'm not a demonstrative person. I'm German. Us Germans don't love to love on people very much. And I went home to my husband and said, what a nice group of folks. They all hugged me. It was a great reception, just a warm welcome. So I went in the next day and everyone hugged me. And not just when you get there, but when you leave too. So it's a hug in the door and a hug out the door. So I went home and I told my husband, oh, they hugged me again. That's really nice. And then I went in on the 3rd day and they hugged me again. And I went home to my husband. I said, this is going to challenge my personal space. But I learned to be a hugger, as you'll see. I hug everybody in this room. Well, the ones I know. I don't want to walk up to complete strangers and hug them. I guess I could.
Stay on point, stay on
Yeah,
point.
my bad. But it's this job has pushed my limits as well to make me more of a personable person instead of the German that's built deep inside of me. And I want to thank the staff for that. They kind of force you to do that, and I came around. So it's a family. I will stay in touch with a lot of people here, and this will not be the end of my activity in state government. I'm going to be a Texan during the 87th session and visit the Capitol and testify on a few items that are near and dear to my heart, this agency being one of them. So thank
Super.
you for leading this agency. Thank you, executive staff, for welcoming me and helping me not get fired. And thank you, TDLR staff, for the strong presence you are for Texans and the hard work you put in every day.
Super,
Thank you.
super, excellent.
Mr. Francis, is there anything you'd like to say?
I am next. Yeah, and I talked about this at Carla's retirement celebration last week. She had her in-laws there. Her mother-in-law is the cutest little thing in the world. She sings, I say gospel, but it's probably not gospel. She sings gospel music. And her husband was there, and true to form for the most recent retirements, the spouses were crying because they realized how much of a sacrifice and how important that their family members have been to this family. And something you just said, Carla, is that, you know, we've moved because of our size from a family to a community. I think there's a lot of truth to that statement, that we're bigger than just, you know, the immediate family, that we have become a community of souls that believe in serving Texans. Thank you for the hard work. Thank you for the dissonance, as I told you earlier. You talked about how this job pushed you to change and challenge your personal limits. You pushed me to change as well. Commissioner Collier is absolutely right. Right person at the right time. Having folks that would have looked and spoke just like me around probably would not have moved me and grown me as a leader. And so I appreciate you for sharpening me with the iron that you brought to the table. I appreciate you for the commitment that you had for the employees. Carla is an incredible mentor. And to watch the folks that she mentored embrace her, and I know she said she's not a hugger, but they were long and they were real and they were genuine because you affected and you've changed their lives on a daily basis. The decisions and choices they make, you know, I'm looking at a few of them right now. They're in positions today because of the conversations that you did to encourage them, to help them, to inspire them. And you're going to continue to be that light for a lot of folks. So, I look forward to seeing you during the session. I know you're going to give them what for. Oh my gosh, I cannot wait for them to say, you have 2 minutes, ma'am. And you're like, I'm taking the full 2 minutes here. It's going to be exciting. So thank you for everything you've done, and I appreciate you helping me become a better leader I am today. Thank you.
Will you join me on the podium? All right. You all here? I'm supposed to read some. Oh, that better? Can you hear me? Okay. Okay. All right. I got to read some talking points, but you know, Carla, and the salient points aren't on this paper. The salient points are in her heart and what has been testified here. And you are a UT grad, which I don't know if you're going to find a job, but it's a good vocational school. It's a good. It's a good. That's what all UT grads say, but that's another point. Anyway. 23 years here and for service is amazing, or 25 as you stated, sorry, 25. The amount of work, and I could list all this out, but just in the consolidation of all this, I call it the quiet giants that the state of Texas will never notice. You are a quiet giant because the state of Texas always notices when you don't do your job, but very few times do they recognize when you do your job. And at a moment like this, we officially are recognizing you did do your job. And you did it well. And the state of Texas is better because you're part of it. And I'm looking forward to what Mr. Francis said over there, that you giving them hell at the legislature. And don't tell them we sent you, whatever you do, because we'll get our budgets cut. But on behalf, we'd like to give you a certificate. It has a famous signature on it. You can hawk that at a pawn shop later. And a gift on behalf of the, it's framed.
Thank you
So, ladies and gentlemen, Ms. Carla James. Is that it, Tamla? All right.
Carla, you are now dismissed. You do not have to stay for this whole meeting. So hit the road and terrorize some people on it.
So I will say, being someone with great integrity, I'm getting paid today, so I'm staying.
Oh, I love it.
All right. Enough with the mushy stuff now. All right, so, Tamla, do we have any public comments? Okay. Okay, so we're going to move to executive session. Let me read this to you if you don't mind. We'll now go to executive session to consult with our attorneys under section 551.0711 and 551.072 Governance Code. The time is 8:48. Okay, we're coming back from executive session. The time is 9:18 a.m., and there was no actions from executive session. We have 2 minutes that we need to approve, August 6th, 2019, and October 1st, 2019. There's a technical glitch on the 6th meeting, so I need a motion, if you don't mind.
Make a motion to approve those minutes for those days on August 6th and October 1st.
A second.
All in favor?
Aye.
All right. On to contested cases. If you're here today for a case and you wish to speak to the commission, we'll call you up when you announce your case. We'll hear from the prosecutor first, then we'll have the opportunity to speak. Make sure you fill out the public comment form, which is right here. Make sure we add it to give it to Tamala, if you don't mind. And if you want to speak, then also use the microphone, state your name, and so you can speak clearly. Very important part with cases. The commission can only consider information that is in the record from the case was heard at SOA. You must limit your comments to those matters that were present in the SOA hearing. And I'll try to put you back. I'm not trying to be rude, but again, we just want to contain all the facts that were at the SOA. We don't want anything outside of that. Because if you do that, then I get my hand slapped by Mr. Bowman over there, and that's not a pleasant experience. So, all right, so we're going to go with the case, Frederick Williams. Is that right? And prosecutor's Amanda Barra. Okay.
Good morning, Chairman and Commissioners. My name is Amanda Barrera, and I am a prosecutor that represented the department at the SOA hearing on July 30th, 2019. In the proposal for decision, the ALJ recommended a penalty of $3,500 for performing unlicensed air conditioning and refrigeration work. I recommend you adopt the PFD as written. The facts of this case are not in dispute. At the hearing, Mr. Williams admitted to being unlicensed and admitted to performing ACR work for Ms. Stacy Smith. Ms. Smith operates an in-home daycare and had recently constructed an addition to her home for the daycare. She believed the AC needed to be cleaned to increase airflow to the daycare room. Ms. Smith found an ad placed by Mr. Williams that included multiple license numbers, which Ms. Smith testified gave her the impression Mr. Williams was qualified to perform ACR work. The evidence showed, however, these numbers corresponded to an assumed name certificate and a U.S. Universal Technician Number, which is a certificate issued by the U.S. EPA Stratospheric Protection Division. None of these numbers were issued by TDLR, nor did they qualify him to perform ACR work. Ms. Smith hired Mr. Williams to clean out her AC. However, the AC was not properly cleaned and the airflow did not improve. Mr. Williams checked the existing ducts in Ms. Smith's attic and developed a plan to add duct work to increase the airflow. After Mr. Williams' visit, there was a leak in the attic, which caused water damage to Ms. Smith's living room ceiling. Mr. Williams came and inspected the problem and told Ms. Smith he had fixed the drainage pan. Mr. Williams again returned and he cut ducts, cut new ceiling vents, installed the ducts with tapes and mastic, and installed an attic fan to help increase the airflow. On July 31st, 2018, the AC unit stopped working altogether. Ms. Smith was forced to hire a subsequent company to fix her AC unit and the work done by Mr. Williams. The subsequent company documented the deficiencies of Mr. Williams' work, including coils that were clogged and uncleaned, use of the wrong material to cover a cutout, improper installation of a duct fan, an open electronic junction inside the plenum, improper sealing and taping of the plenum, and he left exposed electric connections in the attic. At one point, the daycare room was at 95 degrees. In an attempt to alleviate the children from the loss of the AC, Ms. Smith purchased fans and window coverings to cool down the room. She had to repeatedly assure parents that she was doing everything that she could to remedy the situation, and her family had to suffer at night. The ALJ found the undisputed evidence showed Mr. Williams performed ACR work when he did not hold the appropriate air conditioning and refrigeration license. In addition, the ALJ found Mr. Williams' work was poorly done, and in addition to financial loss, caused harm to Ms. Smith's business and physical discomfort to her family for weeks in late July during the hottest time of the year. When determining the penalty, the ALJ stated that the factors the department is required to consider supports a large penalty and that Mr. Williams' violation was a serious one. The ALJ recommended the penalty of $3,500 for this violation, and I would recommend that you adopt the PFD as presented, and I'm available for any questions.
Any questions for Ms. Pereira?
Thank you. Just one question. I mean, to date, has Mr. Williams resumed his application process to the agency?
As of the hearing, he had not.
And it was confirmed that he was not licensed, whatever state he was from. I can't remember right now.
Mr. Williams was under the impression that his certificate from school, as well as this EPA certificate, allowed him to work in Tennessee. I don't know the requirements for Tennessee. However, when he came into Texas, he testified he did not check TDLR, he did not check what the requirements here in Texas were, and presumed that he was licensed and performed these activities.
And just to, I believe it was a segment that I read that when he contacted the name of the company who, I guess, had installed the first unit, and I forget the name of the entity, that he professed that he was a landlord.
That is what the Ms. Smith testified to. Mr. Williams did not contest that.
More questions, Mr. Chairman?
Any other questions? Okay, I'll entertain a motion.
I move that we accept the PFD as is, as written.
Second.
All in favor?
Aye.
Motion carried. Thank you.
Thank you, Chairman. Thank you, Commissioners.
Great job.
Thank you.
Sharp and Ulina, Mr. Ulina and Friends Auto Trucks. I think we have two. Under there, it's going to be Troy Wilson and Jonathan Bruce. Is that right? These two? Okay. Is there Mr. Are you Mr. Wilson?
Yes.
Okay, Mr. Bruce? Okay, you had J2. Okay. This is not, this, okay, that's fine. I got you. I think it's- Okay, Mr. Wilson, hang on, we'll get right to you. Extra, it's their case. All right, Mr. Sharp, good to see you, sir.
And you too, sir. And good morning to you, Mr. Chairman and Commissioners.
Sharp?
My name is Ken Sharp, for the record, and I'm a prosecutor with the Enforcement Division here at TDLR. This next case involves the respondent Friends Auto Truck and Industrial Equipment, LLC. The owner and sole controlling person is Okizi N. Ulinya. The department seeks to deny the renewal application for a used auto parts recycler business license and to revoke that license based on the criminal conduct of Mr. Ulinya and his lack of honesty, integrity, and trustworthiness. Originally, the department also sought to revoke Mr. Ulinya's used auto parts recycling, that's APR for short, his APR employee license, but the legislature recently repealed the requirement for an APR employee license, so that's really not an issue in this case, although his conduct in the course of applying for the renewal of that license is relevant. You have a handout there, and I'm going to refer to the information in Part 1 of that timeline handout. On March the 21st of 2013, the department issued a used auto parts recycler, or like I said, APR, employee license to Mr. Ulinya. And then on February 4th of 2017, Mr. Ulinya applied to renew his APR employee license, and he answered yes to the criminal history question on the renewal application. It appears that he may not have submitted a completed criminal history questionnaire because on February 14th of 2017, the department sent a written request to Mr. Ulinya directing him to complete and submit a criminal history questionnaire explaining his response to the criminal history question on the employee license renewal application. Now, on February 17 of 2017, Mr. Ulinya pled guilty to the first-degree felony offense of theft, more than $200,000 in value, and he was placed on deferred adjudication for 10 years, and during that time, he was required to pay restitution of $250,000. According to the evidence that was presented at the hearing, from 2009 to 2011, Mr. Ulinya operated a medical patient transport business, and he derived a significant part of his income, or the business revenues, from billing Medicare and Medicaid. The evidence showed at the hearing that all operators, like Mr. Ulinya, are provided with manuals that clearly state which services lawfully qualify for compensation from Medicare and Medicaid. It also, the evidence showed that all operators are required to comply with those provisions in those manuals, and of course with the law. Well, contrary to the provisions of that manual and the law, Mr. Uliña billed for individual transports, although he actually transported more than one patient at a time. And in doing that, he charged full mileage for each patient when the law required him to split it up among the patients, to allocate those costs among the patients being transported. He billed the services as transportation from residences to hospitals, but many times the destinations where he took people were not hospitals, and that was not authorized. Now, finally, some of those transports involved multiple passengers in passenger vans and not in ambulances, and that is not eligible for payment. Mr. Uliña's guilty plea and his deferred adjudication came on February 17th of 2017. On February 27, 10 days later, Mr. Uliña faxed the department's request letter of 2 weeks earlier that I referred to mentioning a minute ago. He faxed that letter back to the department with a handwritten note signed by Mr. Uliña in which he said he had no criminal record to stop his renewal. Well, his APR employee license was renewed, and that license expired in April of 2018. But he remained eligible to renew that license at that time, and so that's why the department sought to revoke it at the beginning of this case. Now we move on to Part 2 of the handout that you have. On July 10th of 2017, the department received Mr. Uliña's application for a used auto parts recycler license. That's the APR business license. It included a completed criminal history questionnaire, and in that he stated that he had a medical transport business and was charged for theft, although he never billed or charged patients for transporting them or the doctors that he claimed ordered the transports. And that would be true if he only billed the Medicare and Medicaid programs. And please note, because this becomes significant later, that Mr. Uliña answered the question on the form that asked whether he had had any occupational license or registration or certification revoked or suspended. And he answered that question, and he answered it no. In July 2017, the department issued that APR business license to Friends Auto Truck and Equipment LLC, pursuant to the application Mr. Uliña submitted. Now, Part 3 of that handout. The Texas Department of Motor Vehicles, we know it as DMV, they had issued a salvage motor vehicle dealer license to Mr. Uliña, or actually to the company, back in 2013. On February 28th of 2018, the DMV revoked that license. And this is significant because 4 months later, on June 26th of 2018, Mr. Uliña applied to renew that APR business license. And just like the original application he had completed a year earlier, the renewal form asks whether an owner, partner, or principal, and so forth, had ever had an occupational license or certification or registration suspended or revoked. This time, Mr. Uliña did not answer the question or complete the disciplinary action questionnaire that was required. On July 2nd of 2018, the department sent a letter to Mr. Uliña directing him to answer that question, and if the answer was yes, to complete and submit a disciplinary action questionnaire. On July 27th of 2018, the department received a letter from Mr. Uliña and a disciplinary action questionnaire in which he disclosed the revocation of his salvage dealer license, but claimed to have no knowledge of any legal reason why DMV revoked it, even though the revocation and the revocation orders in evidence clearly stated that it was because of his deferred adjudication and because of the provisions in the Occupations Code, and they cited the chapters, the specific chapters. And then that leads us to Part 4 of the handout. Now, the fraud against Medicare and Medicaid, I mean, that's bad. The misrepresentations, either if they were direct or by omission in the application and the renewal processes, if they were deliberate, of course, that would reflect a lack of honesty, integrity to some measure. But perhaps the most reliable indication of Mr. Uliña's lack of honesty, integrity, and trustworthiness appears in his testimony under oath at the administrative hearing. Now, at the hearing, when he was testifying, he was asked by his attorney to describe what he currently does in his APR business. And he testified that he deals in auto parts and performs auto repairs and also buys salvage cars from auctions, some of which he uses the parts for, and then other salvage vehicles, he fixes them up and sells them. And then under cross-examination, I again asked him and emphasized that I was asking him about his current business, And again, he testified that he buys and sells salvage motor vehicles, and in fact, only salvage motor vehicles. And you have a partial transcript of the testimony, the one that the part that I'm talking about. That's attached to your handout. Well, then, when confronted about still being in the salvage vehicle business, Mr. Uliña stammered a bit and then said that he was describing what he used to do in his business before his salvage license was revoked, even though it was very clear that his attorney and I had both asked him about what he does now. This leads to two things to consider. First, that Mr. Uliña would disregard the law and engage in unlicensed activity, not only when he just did not have a license, but when he had had a license and that license had been revoked. Now, the second thing is that he would then, and I don't say this lightly because, you know, this is a hard thing to say, but the second thing is that he would then blatantly lie under oath about it after he was confronted with the unlicensed activity. And you can read the transcript of the testimony yourself, and then you can see what I mean. The ALJ wrote that although Mr. Uliña bills insurance companies for auto repairs, he does not bill them for used auto parts, so there's no opportunity for fraudulent billing. Well, that, however, ignores the fact that auto repair necessarily involves replacement of parts. Mr. Uliña wants a license to sell parts that are used for auto repair, which repairs and parts are then billed to, among others, insurance companies. So the ALJ's conclusion in that regard is erroneous. Now, it is true, as the ALJ noted, that it's been about 8 years since his criminal activity in the ambulance or medical transport business, which had extended over a 2-year period before the Health and Human Services inspectors detected his offense. But it's also true that there was no evidence of any kind of rehabilitation or rehabilitation efforts. Moreover, as the ALJ noted, he testified at the hearing that essentially he was innocent, that he simply made an innocent error. But to the criminal court, he pled guilty and even signed a statement admitting the allegations were true, that he intentionally committed an offense. And these things are in the record, too. He stated to the court that he committed each and every element of the offense the state had alleged. Now, the ALJ concluded the deferred adjudication should not be treated as a conviction for licensing purposes, in large part because the theft was committed against government entities, and Mr. Uliña is not now in a position to defraud government entities. And finally, the ALJ completely ignored Mr. Uliña's disregard of the motor vehicle dealer law and unlicensed activity and his obvious perjury, and ultimately concluded that despite all these circumstances, he has all the honesty, integrity, and trustworthiness to hold a license issued by the department. The department respectfully disagrees with the administrative law judge. Mr. Uliña's willingness to commit theft based on fraudulent billing to the government, his omission of significant information specifically it requested, the disclosure of information only after the department specifically requested it, the mischaracterization of his offense at the hearing compared to what he told the criminal trial court, his disregard of the law as shown by his unlicensed activity after his salvage vehicle dealer license was revoked, and his perjury at the administrative hearing. All of these things can only lead to one rational conclusion, and that's that the deferred adjudication should be treated as a conviction for our purposes here today. It also leads to the conclusion that Mr. Uliña is not currently fit to hold a license issued by TDLR and that he lacks the honesty, integrity, and trustworthiness to hold such a license. The department asks that you reject the PFD and or to issue an order that's consistent with the exceptions filed by the department in this case. Thank you.
Thank you, Mr. Sharp. Any questions for Mr. Sharp? Okay. Mr. Wilson, state your name again, contained it to the context of what was stated at the SOA hearing, if you don't mind, okay? And speak directly in the microphone.
Thank you. My name is Troy J. Wilson. I'm an attorney. I represent Mr. Uliña as well as Friends Auto. I also represented him in the SOA hearing, and I also represented him before the judge and negotiated the deferred adjudication of which counsel speaks. We are asking that the PFD be affirmed. We think that the administrative law judge had the opportunity to consider everything that counsel has presented to you today, not just once but twice when they made their exceptions. The ALJ rejected their position from the hearing and rejected it in the exceptions. And I think the reason for that is, first of all, some of the claims that are being made relative to perjury During the testimony, and one purpose of having the hearings, the judge is the person who decides credibility. And the judge heard Mr. Ulinha's entire testimony, the part that has been excerpted and put into the document that was given to us a few minutes ago is a part of the testimony, but the judge heard the entire testimony. And she issued findings of facts, I think 29 different findings of facts. She did not issue a finding that Mr. Ulinha had committed perjury or had lied relative to unlicensed activity. Secondly, I think it's very important, the ALJ had the opportunity to listen to his testimony and to hear the witnesses that were brought by counsel at that hearing relative to the deferred adjudication and what led to the deferred adjudication. On page 9 of the PFD, she specifically states that Mr. Ulinha claimed that he always had physician orders for the patients his business transported, and the services were billed to or paid by Medicare or Medicaid. These Medicare and Medicaid billings led to Mr. Ulinha's criminal indictment. The billings that took place that led to the deferred adjudication were pursuant to doctor orders. There was never any evidence that he did anything other than follow doctor orders. I think the evidence established that there were facilities where these patients had been directed to pursuant to those orders that did not qualify. And that is why those monies were disallowed and were attributed to Mr. Ulinha for theft. In fact, if you read through the PFD, the amount of money that was initially charged was tremendously more than what he eventually pled to. And plea bargains happen. A deferred adjudication is a plea that is entered where everybody knows the person is not going to be found guilty. The very nature of it says it's going to be deferred. And eventually, if you do everything you're supposed to do, the charges are actually dismissed. In the case of Mr. Ulinha and rehabilitation, counsel said there's nothing to show rehabilitation, but the administrative judge notes in her PFD that since the time he has been on deferred adjudication, there have been no violations. He's been in compliance with everything. And one of the main things that she pointed out in the PFD is that at the time of the deferred adjudication plea, the court as well as the state was aware of the business that he was in, the current business that they're trying to revoke the license for. The court was aware of it, the state was aware of it. In fact, one of the purposes of allowing him to be on deferred adjudication was to pay back the $250,000 at the rate of $1,000 a month with several lump sum payments. Everybody knew at that point that the source of that money was going to be the business that he's currently in, and that at this point, a revocation of that would eliminate the source of repaying that money. So the court was fully aware of it. In fact, one of the conditions that was introduced into evidence, all of his conditions were introduced into evidence. The main thing, there was no community service ordered or anything of that nature, because the court wanted him to pay the money back, wanted him to work to pay the money back. And during the course of testimony, it was made clear that he has an excellent relationship with the probation folk who are supervising him, that he has adhered to everything. Also, in the proposed findings for decision, the judge concludes that all of the incidents that took place relative to the charge, the very last one happened in 2011, and there has been no allegations of any kind of violations or fraud or anything of that nature on the part of Mr. Ulinha. One other thing that was very important, I think, that the administrative law judge saw and put into her PFD is the fact that despite what counsel says that Mr. Ulinia did not disclose his criminal history. The ALJ and she mentions it several times, that he disclosed things even when he didn't have to, that he went beyond the call of duty to disclose when he didn't have to. In a footnote, she talks about how he answered it. It wasn't even required of him to answer at that point, but he did. They harp on the fact that there were some omissions. These were all after the fact that he had already disclosed the criminal history.
I'm not seeing that. Where was that kind of language in?
Let me find it. It's in a footnote in the PFD.
Is it one of the findings?
Pardon me?
Conclusions of law, or was it one of the findings?
It's on page 15,
Page
footnote
15.
number 47. In fact, Mr. Ulinia's disclosure on the renewal application was gratuitous. On page
Yes.
15, footnote number 47.
Thank you.
47, 47, 47. Okay, got it. Okay, got it.
And I think even that footnote shows the thorough nature of consideration that the administrative law judge gave to this case to make sure that every fact that was presented is included in the PFD. Our position here is that Mr. Ulinia, he had a problem. The problem was not direct. I don't even know how to word it. He was in business. He was getting doctor orders to take patients to specific facilities. It wasn't his job to know this facility is a hospital. It was called the hospital. The doctor sent him there. He followed the doctor's orders. It came out that some of these things were not appropriately billed because those facilities did not qualify. That was the nature of the theft, and that is what he is paying back. In terms of his business, he has not had problems and violations. I think in the PFD, I think in November of 2018, either November of 2018 or December 2018, the ALJ says that there was a site inspection there by the state, and they found nothing wrong with what he was doing. And so I think when you look at the totality of it and the length of time that it has been since all of this stuff occurred, and his actions since being placed on deferred adjudication, that it shows not only rehabilitation, but a consistent effort to do what's right. And the last thing I will say is this. There was a time when if you got deferred adjudication, you didn't have to really worry about your license being revoked. I mean, even as a lawyer, you know, I get deferred adjudication, I'm okay in most instances. The state presented a discovery, presented its case in full before the ALJ. They made their exceptions. The ALJ, after their exceptions, took a look at it, came back and said, look, there is nothing here that convinces me anything otherwise. And so what we're asking, which is usually their position, we're asking for the PFD to be adopted. We think that the judge was in position to judge the credibility of the witnesses. The judge was in the position to judge the credibility of the evidence. And we think the evidence in this case shows a man who made some mistakes a long time ago, owned up to the responsibility of those mistakes, and is working diligently to make sure that that kind of thing doesn't happen again. Thank you.
Thank you, Mr. Wilson.
Thank you.
Any questions for Mr. Wilson?
And Mr. Wilson, how long, because I believe there was a community service component to it, how long is that, and where are we within that process?
There was no community service component, and usually community service in deferred adjudication cases usually is automatic. But because of the amount of money that has to be repaid, the court allowed him, waived the community service aspect so that he could work.
Commissioner, this is Brad Bowman, General Counsel. Are you referring to the community supervision, the
Yeah.
probation,
Yeah,
essentially?
thank you,
the
Brad,
length of
for
time
that,
the-
correct.
Oh,
It's at the
you're
time
talking about,
here.
well, it was a 10-year deferred. It was entered, I think, in February of 2017. So you would
Okay,
be,
so through 2027.
right.
Can you,
And it's eligible, if he has paid all the money, it's eligible to be terminated 5 years in 2022.
that was gonna be my next question. Is he up to date on payments?
Yes, he's paid every month.
Is he ahead on payment schedule or up to date?
He's up to
Up
date.
to date, okay.
I don't think he's
And-
ahead.
I just want to make sure is that in the
Is that in the
record?
record?
Was there
Sure.
evidence of that?
At the time of the hearing?
Yes, sir.
The record the testimony there indicated that he was up to date at the time of the hearing.
And then, over what period of time did the violations occur?
Well, the
Is that-
thefts from Medicaid and Medicare occurred from 2009 through 2011 when he was in business with the ambulance transport business.
But 2017 was when the conviction occurred.
That's when the deferred
Conviction
adjudication
occurred,
order
yes.
was
Yes.
issued.
Any questions for Mr. Sharp?
I do have some additional information, if I may. It's true that the ALJ did not address the false testimony in the PFD, did not address it at all, not just didn't say anything about it, but just ignored it altogether, apparently. The part about always having a physician's order, there's no evidence that the doctors transported or ordered transports and ordered billing to Medicare and Medicaid contrary to the law. And even if a doctor had ordered a transport, that doesn't mean that it automatically qualifies for Medicare and Medicaid. Those provisions in that manual, the law that governs Medicare and Medicaid, those are the things that determine whether a person is eligible to be reimbursed, not whether a doctor ordered it. And it's the person who is making the claim to Medicare and Medicaid to make sure, it's that person's responsibility to make sure that that claim is correct, just like if you and I made a insurance claim to our insurance company. And as far as what the court does, the criminal court does, it's not the criminal court's place to tell the commission what to do any more than it's the commission's place to tell the criminal courts what to do. So whatever they do, that's up to them, and it may be aspirational in one direction or another, but it doesn't have anything to do with what we do here today. And then there was a comment that he had disclosed, I think we were talking about the footnote 47 there. And, well, yes, by that time, he had learned that when he files these applications, TDLR is going to say, hey, you need to provide this information. So it's no wonder that he also, in that business renewal application, also then submitted that information that he had already submitted about his criminal deferred adjudication. That's all I have. Thank you.
And is it, Mr. Sharp, confirmed that since 2011, no violations?
That was his testimony.
There's no evidence to the contrary.
I want to remind the commissioners, if you do find a modification to PFD, that make sure the findings, the fact findings, you look at those specifically that you want to take issue with. And this was a first-degree felony.
Yes, huh? Because of the amount of money alleged, yes.
Okay. Okay.
And may I add, even though counsel says, well, the doctor's orders and whatnot basically are not determinative, if you're in the transport business or doing any kind of healthcare or anything, those orders usually are what's directing you. Most people are not questioning doctor orders.
Was there evidence of this in the hearing or testimony about this in the hearing? And may I add one further
Concerning-
point? It seems like we may be getting into sort of relitigating some of the underlying facts of the criminal disposition.
I'm sorry, I didn't understand what you're asking. Yes, if something was in,
the point that you're making, is that was there testimony about that in the record, about the billing and how that works with the doctors? And then, again, I'm just kind of raising for Mr. Chairman, for your consideration, is are we getting too much into the underlying facts of the criminal matter and sort of relitigating that beyond what's in the PFD?
Well, I think it was in the record, and I think in the PFD, the ALJ makes reference to it.
And I think if I may, the testimony was that Mr. Ulinia didn't question the doctor's orders for transport. Not that nobody does, but that Mr. Ulinia doesn't.
Yeah, I agree with
Or
that.
didn't.
I agree with that.
To council's point, we just, I think we want to make sure that we're not relitigating the case. We're just looking at the overall points. Okay? Comments from commissioners?
Yeah, Mr. Chairman, I mean, my only comment is that, I mean, it's still under community supervision, you know, at this time through 2027, so it's, that's my challenge in that regards. I mean, aside from the,
Is there a particular fact finding or conclusion that you wanted to highlight? Well, they're thinking it is a precarious position, Mr. Sharp, that usually the ALJ is, that's our eyes and ears, and so there's a lot of reverence that I personally put into those statements.
Certainly.
To the point, counsel, in my opinion, is that I don't like to relitigate cases that will contain now. Under that auspice, but there is a latitude that's given to us that we need to always consider. But it is a unique position, and so I want to give the commissioners as much time as possible. Do you have any further questions for Mr. Wilson or Mr. Sharp?
I don't think so.
I'll entertain a motion when you're ready.
again, his employee's license, that's totally separate.
The
Mr. Callier, that license is no longer required as of September 1, so it's really not an issue.
So I'd like to propose that we look at, I mean, for me, I have to align it with the community supervision, with the 2027. So if we look to, and I'm not sure, you know, being under probation, how can we align that if it goes under, if we suspend it and probate, or can we revoke it for, and then?
So this is Brad Bowman, General Counsel. If I could back up for just a second, since the PFD recommended no disciplinary action.
Got it.
In order to impose any kind of disciplinary action, whatever that might be, if you find that the ALJ did not correctly interpret or apply the law, then you have latitude to change particular conclusions that would warrant, if you warrant disciplinary action. If we kind of start from that premise, it sounds like maybe that's where you're headed. If you are looking at imposing some kind of suspension, like a probated suspension, maybe I just need to kind of hear what your, is it a probated suspension for the term of the criminal probation? Is that kind of what you're?
Yeah, I mean, it's aligning it with the 2027, you know, date. If, you know, for whatever, if it's good behavior or whatever the appropriate language is, and that's shortened, then it's, you know, if it's 5 years, then it just aligns, you know, accordingly. I mean, that's my only, concern. I'm not sure if the other commissioners have any thoughts to it for me.
So what you could do would be to suspend the license, the company license, for that period of time, and then fully probate the suspension, provided that the respondent complies with standard terms and conditions, complies with the rules and laws of the department, as well as the criminal community supervision in the criminal matter. And what I'm hearing, and I think you would have to change certain findings of fact and conclusions of law, and the ones that I would think are at issue are finding of fact number 20, to emphasize that this is an offense that is directly related to the licensed occupation under the department's guidelines. Conclusion of law number 7, 9, 11, and 12.
13.
And 13, thank you.
All in basically revocation, suspension with the probationary status, incongruent with the probationary status, which is
2027.
2027.
Okay.
And then
Is that what-
possibly 2022, like you said it earlier, right? If he can
Right.
get out from under the full 10 years.
Right. If-
So whichever one comes first.
These are your thoughts, we want to aggregate them. So basically, right, we're looking at revocation or suspension, right? Right, with the probation of that, congruent with his probation, which is 2017 or 2022. 2027, I'm sorry, in 2022. Facts finding 20, 7, 9, 11, 12, and 13.
And can I back up for just a second? Is the basis for doing this the deferred adjudication, the seriousness of that matter, the relation to the offense? Is that your reasoning
That's my reasoning.
for doing that?
Right.
Mine would be the felony, the first degree felony. That's in the context of the fact that it is ranked that high.
And the seriousness of the offense is
Oh,
one
absolutely.
of the main factors to be considered, certainly.
Okay.
So a probated suspension for that period of time, is that
Basically, yes.
what you're,
I'm sorry.
I guess probated suspension or probated revocation? Because initially we're asking for a revocation.
Right. Right. I mean, to me, it needs to be.
Right.
No, I agree. I mean, the seriousness, I'm in alignment with that. I
Right.
mean, I don't know
Right,
the other
right.
commission, but the idea is, the probation of it, it means he continues to work.
Right.
So,
Okay.
you
got it.
understand,
Okay,
he continues to work,
right.
but there is a weight hanging over his head on this because of the fact, the seriousness of the crime.
Right.
Does that make sense?
Right.
Is that accurate, Brad? I mean,
Mr. Chairman, I might offer, would the commission want to take a brief recess, and we can perhaps huddle at the staff level?
Sure.
I could even confer with a single commissioner, not the full commission, but about the crafting of that motion,
okay.
if
Why don't we do that?
necessary.
Why
If
don't we-
that-
why don't
if
we-
that's
sure,
if that's what
fine.
you.
Why don't we
if
do
that's
that? Why
what
don't we
we-
give us a 5-minute?
Before you do, he still has to apply for renewal every year, correct?
Yes.
Mr. Wilson,
Yeah.
I think you're going to be on a path that you would appreciate.
So won't you stand by? All right, so why don't we take it?
Okay.
Take a 2-minute, 3-minute little attorney break, if you don't mind. And the time is 10:01, and we're going to go into executive session. All right.
Yeah, she jumped in already.
Call the meeting back to order. Time is 10:12. Mr. Oliver, thank you. Mr. Wilson, thank you for your patience on this. Sharp as well. Commissioners, any other comments? Questions? All right.
Okay, all righty. So based on the seriousness of the felony offense, associated with the Medicaid, Medicare, which is, of huge nature, and the fact that it's still under, community supervision until 2027. Again, as I noted earlier, I have a problem with that. And I think with the closeness of the activities that, as to what he's doing right now, so we've, going to look to modify the PFD.
And, Mr. Chairman, this is Brad Bowman, General Counsel, did confer with Commissioner Callier, and the terms, was going to lay out the terms, and if it's acceptable, Commissioner Callier, you could make this as your motion. Changing the PFD to revoke the license, but fully probate the revocation until the end of the respondent's community supervision in 2027, or if the community supervision is terminated earlier, then the
Right.
Commission's order would end at that point. And changing findings of fact 20, conclusions of law 7, 9, 11, 12, and 13, disagreeing with the ALJ's application of the law, the factors in Chapter 53 and 51, and applying standard terms to the probation, complying with the department's statutes and rules, complying with the terms of the respondent's community supervision, and two additional requirements. One, that on renewal, the respondent notify the department prosecutor in writing of the status of the community supervision. So if there's been any change in that status. And then, and similarly, a requirement that the respondent notify the enforcement prosecutor within 30 days after any change in the status of community supervision.
So at renewal, notification of any change of the community service, and then in 30 days of any modification at all to that status.
To the community
Right.
supervision.
So
Is that your motion?
That's the motion.
Okay. So we got the fact findings. You got the fact findings, correct? Okay. So does everybody understand her motion?
Yes.
Okay. Is there a second to that motion?
I'll second.
Okay. Any discussion? Okay. I want you guys to know that, right, we're always making sure that citizens of Texas understand what we're trying to do here, the seriousness of the crime. There's always a balance. We respect the LAJ, I personally do, and how they see things in the enforcement division, what they go after, the integrity of this licensing. I always make it my job to make sure that we are not a hindrance, but we sure are not a doormat to walk by. So I think Commissioner's got this pretty spot on. I hope the defendant understands that. I hope he understands what we're trying to do here and make it as clear as possible. I don't think he's here today, correct?
No, he's here.
Is he?
Yes.
Okay. I want to make sure that you understand what we're trying to do today. Okay? Does it make sense? Because sometimes in the vocabulary of all this, the main crux gets lost. And I think the commissioners are trying to find that balance here. All right. So we have a motion, second. All in favor, say aye.
Aye.
Opposed? Okay, motion carries. Thank you, Mr.
Thank you.
Ms. Sharp, thank you. I think, are you next? No.
I am, sir.
No, sure. Yeah, you're next.
I'm not.
Yes, you are. Yeah, you're up next. I apologize. And Mr. Petty. Is anybody here on behalf of Mr. Petty?
Haven't seen anyone.
Okay.
This is the case. I'll be going through all of these.
No, you're not going to read it. We're going to take a break and we're having a conversation.
My name is Ken Sharp. I'm enforcement prosecutor with TDLR. The respondent in this case is Glenn Greg Petty. He is a doctor of podiatric medicine. Dr. Petty's been licensed as a podiatrist since July 10th of 1998. He applied to renew that license in October of 2018. The administrative law judge recommends that you deny the renewal application and revoke the license. On August 14th of 2018, Dr. Petty pled guilty to and received deferred adjudication for, or rather he was convicted of, this was in federal court, so he pled guilty to and he was convicted of health care fraud, and he was placed on probation, federal probation, for 5 years. Now, according to the indictment, the factual basis document that Dr. Petty signed, and the testimony of the federal investigator at the hearing, Dr. Petty had been charging Medicare for administering certain physical therapy exercises in his office under the supervision of a qualified medical profession as required. But in reality, he simply gave the patients a photocopy of the instructions for the exercises and sent them home and told them to do them there. Dr. Petty signed a plea agreement to that effect as well as the written factual basis for the charge, in which he admitted he intentionally submitted false claims for reimbursement for Medicare on many occasions as part of a scheme he devised to defraud the Medicare program. The ALJ in this case concluded that Dr. Petty does not currently have the honesty, integrity, and trustworthiness to hold the license, and that also the ALJ concluded that because of his criminal history, Dr. Petty is not currently fit to be licensed as a podiatrist. The ALJ recommends that you deny Dr. Petty's application to renew his podiatrist license and that you revoke that license. The department asks you to adopt the PFD as written.
Thank you, Mr. Sharp. Any questions for Mr. Sharp? Entertain a motion.
I'll make a motion.
Second.
I'll second.
All in favor, say aye.
Aye.
Opposed? Okay. Carries. Thanks, Mr. Sharp.
Are you sure? Because I got more.
No, I'm good.
Got more?
Okay.
Thank you for your efforts. Okay, Rodolfo Moraz, Mr. Shirk. And,
Mr. Bruce.
John, okay, Mr. Bruce. Just for point of clarification, you're on 3 cases here?
Yes, sir.
Okay, I want to make sure I get that right. All right, Mr. Bruce, good to see you.
Good to see you.
Mr. Shirk.
Chairman Figueroa, members of the commission, good morning. The first case, the administrative law judge, Lindy Hendricks, out of the Houston field office, recommended in her PFD dated August 6, 2019, the respondent's towing company license be revoked and that a $5,000 administrative penalty be imposed for the conduct of flipping in the operation of his business. The facts are pretty much uncontested. On January 12th, 2018, Mrs. Jamie Goodman, the owner of a 2017 RAV4, was involved in a multi-car accident outside of Houston. When respondent's tow truck arrived, Ms. Goodman asked at least twice to have her car towed to a dealership because it was only 6 months old and still under warranty. The tow truck driver told her specifically that he could not do that, and through what the administrative law judge described as, quote, deception, trickery, and misrepresentation, the tow truck driver obtained Mrs. Goodman's signature on documents authorizing the car to be taken to an unregulated body shop, Bammel Collision LLC, rather than a licensed vehicle storage facility. The tow truck driver also obtained an authorization to have work done on the vehicle at Bammel Collision LLC. It just so happens that respondent Rodolfo Merez, DBA 1960 Wrecker, is an officer and manager of Bammel Collision LLC, an unregulated body shop that operates at the same address as his towing company. The vehicle owner, Ms. Goodman, was very clear at the accident scene that she wanted her car taken to a dealership. Her husband, who arrived at the accident scene, also made this request when respondent's tow truck driver delivered the vehicle to the towing company Collision Center. They were each told that the car could not be taken to the dealership. The authorization documents to have the car taken to and repaired by respondent's unregulated body shop were in respondent's tow truck at the accident scene and given to Mrs. Goodman while she was still upset by and in pain from the auto accident. Not only was the nature of the documents misrepresented to Mrs. Goodman, but they were also presented to her in a deceptive manner, with the tow truck driver actually having her sign blank forms and using his hand to cover the caption of the forms, one of which was identified but concealed to be an express power of an attorney. express power of attorney. Based on the evidence, the administrative law judge found that if the vehicle had been taken to a vehicle storage facility, the total cost to recover possession would have been $455. Respondent's body shop charged $1,470 to release the vehicle, despite it being a total loss and incapable of repair. The administrative law judge specifically found that no work was performed on the vehicle, and that because the vehicle was a total loss, there was no legitimate reason to take the car to a body shop, except for the financial benefit of respondent. The ALJ rejected respondent's argument that a towing company cannot be held accountable for the conduct of its drivers merely because the drivers are independent contractors rather than employees. She held that based on the facts in this case and the very definition of towing truck company in the Towing Act, which is a towing company as an individual, association, corporation, or other legal entity that controls, operates, or directs the operation of one or more tow trucks, respondent was properly held accountable for the conduct of its tow driver, who was an independent contractor. This is a necessary and essential interpretation of the Act. Otherwise, tow companies could simply lease their trucks to tow operators, much like a rental car company would rent rental cars to anybody who happens to walk through the doors, and the tow companies would thereby be exonerated from the illegal conduct of their drivers, thereby effectively operating as unregulated entities. The language of the Act neither contemplates nor allows this passive relationship between a towing company and its drivers, regardless of the term by which they are driving the trucks. Therefore, we ask that you uphold and adopt the PFD as written, impose an administrative penalty of $5,000, and revoke respondent's towing company for this egregious instance of flipping.
Thank you, Mr. Short. Any questions? Okay. Mr. Bruce, I'm assuming you've been here before. Just
And-
stay in your lane, man. Stay in
I
your
understand,
lane.
and I
Okay.
want to thank the commission for, I was supposed to be here last time on this case, last year, I had some car issues, and
Ironically.
everything was reset to today, and I appreciate the understanding on that. Mr. Short says, it is our position that all these tow truck drivers were independent contractors. There was no evidence that the licensed tow company holder authorized, knew of, or instructed these drivers to do any of these things, the flipping, that's become the term's been known. There was no evidence that he knew about it or authorized it. Secondly, the department is trying to bootstrap conduct at a body shop and charges at a body shop, which the department doesn't regulate and has no jurisdiction to regulate, and put that liability on the tow company. Third, there is a remedy. Tow truck drivers are licensed. They have their own separate license than company licenses. Unless there is a nexus, an established evidentiary nexus to say, company authorized this activity, told tow truck drivers to go do that, which there was not in this case. And matter of fact, my client testified he never dealt with these people. He holds the license in his individual capacity, not in a corporate capacity. That he never dealt with these people. None of the vehicle owner testified that she never had any dealings with my client. That the proper remedy for the department, and where it should have been against the license of the tow truck driver, because he's the person who committed the acts. It's a matter of law. He is an independent contractor. There was no evidence presented that stated he was an employee. Again, no evidence presented that we authorized these acts. That's the remedy, is to go against the tow truck company. Absent some evidence, again, that the tow truck company, go against the tow truck driver licensee, go against his license. And especially the fact, as a matter of law, he's an independent contractor, and you can't hold the principal liable for acts of an independent contractor absent evidence that they authorized the acts. Nor does the department have authority to regulate activities at a body shop. Can't try to bootstrap what happens because they don't like what's happening at the body shop to the tow truck company. They don't regulate those fees. And And that's, I mean, they just don't have that authority. That's technically what they're trying to do, saying, well, we don't like what happened at the body shops, but we don't regulate body shops, we'll just put it on the tow truck companies, because they happen to be, owned by the same person. And actually, the body shop is a legal entity unto itself, it is a corporate entity. Well, my client may be a officer of the corporation, that doesn't give him any personal liability, nor is the fact that he is a manager or a member of the LLC, that doesn't put, as a matter of law, there is no personal liability on him for what happens with that legal entity. The remedy was go after the tow truck driver, go after his license, not after the company license, especially when my client in his individual capacity never had any dealings, never made one representation to these people. And that's why we believe an order should be issued dismissing this case against my client individually, and the department can go after the driver for the alleged conduct.
And these people, you're referring to the vehicle owner?
Yes. There was never testimony, they couldn't identify my client at the hearing.
The check was written for $1,400, correct?
Correct, and that.
Who got that check?
That was written to the body shop, but something that a corporate entity that this department that the state does not regulate.
Who got the check?
Went to the body shop corporation.
And is your client part of that body shop?
Yeah, he's a manager and I believe it's an LLC. He's the managing and also a member. And I have no problem with an order as far as, I think it was refunded already, but I don't have a problem with them with an order asking us to refund it, but I don't think this amounts to a revocation or a fine.
Questions for Mr. Bruce or Ms. Short?
And just by follow-up, the standard was, in these cases, did they show a lack of honesty and integrity? There was no showing that my client did anything that showed a lack of honesty and integrity in the operation of his business, personally, and he holds the license personally.
So you're saying it's the driver's fault, who was an independent contractor, that he covered up documentation, folded it over, but that the owner of the record company that he uses the truck has their name on the deal. They have no responsibility for what he does?
It depends on a case-by-case basis. If I, as the record owner, as the owner of the license holder of the owner of the company, say, hey, here's what we're going to do. Here's how we can trick these people into signing these repair forms. And there's evidence, and some evidence of that. There was zero evidence of that. Yes, then you could hold the company liable. But here, there was no evidence of that. If I hired an independent contractor, and the reason there's a delineation in the law between independent contractors and employees is because there's certain standards of liability. If an independent contractor goes out and does something that I don't authorize, I don't know about, then no, I'm not liable in that capacity.
Well, I don't know.
And that's how the law recognizes. That's why there's the difference between independent contractor and employee, and that to hold on a respondent superior standard, which was brought up in the case, that's a tort. To hold, that's a tort idea, not a contractual or licensing or administrative theory. So, but yes, by giving the driver a license, you have the authority to regulate his actions that are independent of the company's license.
Any questions? Any other questions?
No. I'd like to make a motion.
Yes, sir.
I move that we do not adopt the PDF as proposed, that we move that the full refund of the however much it was, $1,470.80 be refunded, and that the tow license is not revoked.
How about the penalty?
So no penalty?
So what fact finding are you having an issue with here? conclusion of law.
Let's see here. So it would be conclusion, I think, 10.
Mr. Chairman,
Yes.
I just want to wade in. I think Counselor did an effective job of saying that nobody belongs to nobody. But I don't believe that we have the authority to compel somebody who's not our licensee to do a refund. It's somebody who's paid
Is that
for the body
accurate,
shop.
We just conferred on that, yes. I
Okay.
think that's accurate, since we don't regulate
So you
the body
wanna-
shop.
Okay. So, okay, so let me think that over again.
Commissioners, can I respond to a few of the things Mr. Bruce said? First, on this whole issue of whether or not the driver's conduct is properly attributable to the tow truck company, that issue was briefed. I brought to the court's attention, the administrative law judge's attention, significant case law, one case from the Texas Supreme Court, holding that even if it's an independent contractor, they're deemed a vice principal of the entity for whom they work, for whom they serve, and for whose purpose they operate. The second thing, it's not unusual whatsoever in our rules and our statute for there to be responsibilities and obligations placed on tow truck companies for the conduct of their drivers. For instance, a very simple example is our rules say that a tow truck company shall create and issue a tow ticket and give it to the vehicle owner if the vehicle owner is at the scene. That responsibility is placed on both the driver and the tow truck company. So clearly the legislature and the commission, in adopting rules, recognize that there could be responsibility for conduct that occurs in the field over which the tow truck company would know nothing about. There's one unique responsibility that's essential to this case that is placed exclusively upon the tow truck company and not on the driver, and that is to take a vehicle from a non-consent tow, in this case an incident management tow, to a vehicle storage facility. That is what was not done here. But for that breach of regulation, which serves as proximate cause in this case to show that the tow truck company, the body shop, would not have received that $1,400 in unearned proceeds but for the conduct of the tow truck driver. The driver's conduct is attributable to the business because it wasn't just any body shop, any body shop. It was Mr. Mraz's body shop. It wasn't just any express power of attorney and authorization form that happened to be in the truck. It was Mr. Mraz's express power of attorney and authorization that was in the truck. So clearly there's a confluence. There's an interaction here that's reasonably seen that one was acting on behalf of the other. Certainly the law in the state of Texas, as understood by the administrative law judge, says that a independent contractor can have his or her conduct attributed to the business. Furthermore, I would say that it's really essential in this case to recognize the definition of tow truck company. The Towing and Storage Act does not use passive terms as a tow truck company, owns trucks. It says supervises, controls, and has language of dominion, of control over those trucks. Therefore, those three items, the first, in that our statute and our rules recognize that companies can be responsible for the conduct of drivers, even though the drivers are out in the field. For instance, we've dealt with this innumerable times where the driver makes an illegal tow, but the tow truck company is held accountable. So this is no new law for you. Secondly, the legal arguments that were presented to the administrative law judge finding that a vice principal, that is the employee, can be held responsible for furthering the business of the principal, which is the tow truck company. And third, that we're not dealing with two actors who don't know each other and just cross like ships in the dark. Rather, it was Mr. Mraz's tow truck company, it was Mr. Mraz's body shop, it was Mr. Mraz's forms in the tow truck that happened to be given by the tow truck driver to get it to Mr. Mraz's body shop. The proximate cause of damage was the intersection of both of their actions. This is a flipping case. Revocation sent a strong, muscular, and necessary language to the greater Houston area that the commission will not tolerate this sort of fraud.
Thank you, Ms. Sharp.
Can I respond? Yes, that tow truck companies are responsible for authorized acts of their drivers. There are again, if the tow company authorizes the acts, they are certainly responsible, and they're certainly responsible for any independent contractor to follow the code. Mr. Shirk mentioned the tow tickets. Yes, that's in the act. We authorize you, we tell you, make sure you give a tow ticket, the correct tow ticket. We're not responsible for unauthorized actions. Again, that's why there's delineation between independent contractors and employees in the law. Secondly, when he says furthering the business, again, this is another trying to bootstrap the body shop, which is a separate legal entity, a corporation, with the individual's license. Did it further if the tow truck driver was acting as a vice principal, for anybody, he was acting as for a separate legal entity that this commission and the department does not regulate. Rightly or wrongly, they don't regulate body shops. So you can't link an individual tow truck company license that's held by an individual to a separate corporate entity, which is its own entity, an own person under the eyes of the law here in the state of Texas, to saying, well, it just all kind of links away. The tow truck driver is you can't make that legal link. My client wouldn't be individually responsible for anything the body shop did because it's a corporation. That's why people form corporations. So again, this is just a way to try to bootstrap all into regulation that's something the department doesn't have the authority to regulate.
Thank you, Mr. Bruce. Okay, so, comments? I'll give you mine. This is my own individual. I think it's as classic as it gets, in my opinion, for flipping. I mean, I appreciate the argument, but my opinion is this, and I see it as that case. And that's why I'm a follow the money guy. And that's where I do. That's how I think. But
Well, I
I'm
agree.
one
I was
opinion.
going to make a motion to accept the PFD as written.
Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed?
Aye.
All right, motion carries. 3-1. Did you get that, Tamara?
Yes, sir.
All right. Mr. Bruce, you're still here?
I'm still here.
Mr.
Still
Chairman,
here?
Mr. Chairman, hate to interject this, but I think procedurally, Commissioner Garza had kind of put a motion out there
That's correct.
first.
Oh, did you put, I
and that-
apologize.
That we probably would need to kind of reconsider the
Was
vote
there a
that just
second to that
happened.
motion?
There was not a second on that
I don't think
motion.
so.
It
There was no
failed.
second.
Okay, it failed for
It
lack of
died.
a second. Okay, thank you.
Is that accurate, right? It died a second.
Right.
All right. Mr. Bruce, you know this isn't the last stop. You have
Oh,
other remedies. Okay.
I know.
I'm
I
sure you're
understand.
very familiar with
Yes.
it. Okay. Eurostar Records, Mr. Shirk, you wanna-
Commissioners, this case comes before you on a proposal for decision issued by Administrative Law Judge Stobner on March the 6th, 2019, recommending an administrative penalty of $4,000 and the revocation of Respondent's Towing Company license. This case arises out of Respondent's non-consent tow of a resident's vehicle from her apartment complex on April the 30th, 2018. The administrative law judge found that the respondent lacked any legally recognized authority to tow the vehicle. That is, it was an unauthorized tow. The recommendation of a $4,000 administrative penalty reflects two items. First, her correct understanding of the department's prior enforcement plan, in which a third Class F violation is subject to an administrative penalty of between $3,500 and $4,000, as well as the one-year suspension of respondent's license up to its full revocation. So for a third penalty, this was an appropriate penalty and sanction. However, and more importantly, in addition, the administrative law judge found that license revocation was appropriate because of what she described as respondent's egregious conduct. Specifically, that only 5 days prior to this tow, respondent had entered into an agreed order which revoked its license, but that revocation was probated for a period of 1 year. The conduct made the basis of the agreed order, that is the revocation, which was then probated for 1 year, was substantially similar to the very conduct in this case, and yet 5 days later, respondent makes a tow without legal authority. Revocation is warranted, therefore, not simply for having committed a third Class F violation, but also for violating an order of the executive director as contained in the agreed order of April 25th, 2018. Or, put another way, violating the terms of a probated revocation, which require the implementation of that revocation at this time. Thank you.
If I may respond.
Just give me a second. Any questions, Mr. Short? Bruce?
If I may respond, and this has been an ongoing issue in private property towing. The testimony was clear. This resident parked across 2 parking spots. Not a little bit over the line, but basically diagonally parked underneath covered parking, taking up 2 parking spots in violation of her lease. In her lease, it says you can't take up more than 2 spots. There has been an interpretation, which I have continually disagreed with and still disagree with, that that you can only tow off from apartment complex for the 6 reasons listed in the code, although that just says where a person cannot park. Doesn't say that those are the only reasons that you can tow off. This was not a close call on my client's part. The driver, not my client at the time, but the driver, again, saw the person double parked, taking up 2 spots. She's a longtime resident there. The signs were up. I don't think, again, I just disagree that this was sometimes, Mr. Short makes it sound like we went out and intentionally violated a settlement agreement. No. The contract, and the evidence was with the apartment complex, says tow off for double parking. And under the prior interpretation, under this ruling, that basically means that a apartment resident could take a semi-trailer, tractor and trailer, park across 10 different spots, and there's nothing the apartment complex could do about it. Under this rule rationale, yes, you can park any way you want. You can parallel park over 2 spots, and there's nothing the apartment complex can do about it. My client did what he was hired to do, what's in the lease. This wasn't the driver saw this car double parked, and the resident admitted she was over, in the picture, in the evidence produced, said she was double parked. This was not an intentional action. They didn't go out intentionally try to violate anything. I don't think this amounts to a revocation when it's something that every one of us knows not to do. If you double park, you can get towed. And my client has made the payments on his settlement plan, but I don't believe that this is a revocable offense. Again, there was no intent to violate the terms of the code. But this is an ongoing issue, and this happens practically every day around the state. Vehicles are towed off for being double parked. And it's a badly drafted section. I know it's open for interpretation, but I don't think this amounts to revocation. Maybe a fine, that's fine, and maybe extending their probationary period additionally, but certainly I don't think this is something that warrants revocation.
Thank you, Mr. Bruce.
Yeah.
Any questions for Mr. Bruce, Mr. Short? 2008 was, April 2008 was the agreed upon order, correct?
2018,
2018.
right.
Yeah, 2018, I'm sorry, 2018.
And the conditions of that, if something, transpired, it
Right.
revokes.
And that was signed by,
Mr. Francis.
whatever.
Just one comment that I have is that the code the occupations code started in 2004 when if there's a conflict that's inconsistent between a lease and the actual code, then the code prevails. So it's been around for a while.
Right, but if you read that provision, that doesn't, there's some other, there's a problem in the property code. It says that they can, an apartment complex just has to give notice of a change in parking policies. So that it's contemplated there that to its residents has to give written notice. We're going to say, hey, we're going to a permit system or something like that. They have to give written notice. Under this This doesn't say, here's where you can only tow for. It just says, here's where residents can't leave their vehicles unattended. Says, so if you take this provision, then you couldn't tow for permits either. Every apartment complex I know of in the state of Texas, at least in metropolitan cities, uses a permit system. But if you apply that, this is the only reasons you can tow off, then there's no towing off for permits. And I know there's been kind of some stretching the logic of the permit, of why we can turn off tow for permits. And they're basically saying because they're authorized to park there, or they're unauthorized. I'm not quite sure the department's logic on it, but this just says where you can't park. But it again, and I just don't think that my client understood, he signed a settlement agreement. He said, hey, I got to make sure I do this all right. But in his mind, looking at this, towing off for double parking to be hired was something they could tow off for. They had probable cause, it's a tow hearing, they had probable cause to tow off for that. And again, that puts, this is a husband and wife business, they employ about 5 tow truck drivers, that puts them out of business. They're Venezuelan refugees who come up here and are working hard. And again, if there was an intentional violation, like, oh, you're just over that much and we went and nabbed you. This one was taking up 2 spots. And I just don't think that's a fine, yes, again, but I just don't think that should amount to revocation.
And what was the number of days, Mr. Shirk, that the the incident happened after the,
5 days between the agreed order and the incident.
And some of that might have gone down to just not, there's this big misunderstanding out there in private property towing. Because cars are literally towed off for double parking every day. And that's what and that's, and in tow hearings, which I've done more tow hearings.
I'm going to object. None of this was in the record.
It's got to stay in the record. And we're not trying to relitigate this case.
I know. I'm just saying.
I appreciate your plea, Mr. Bruce.
Yeah.
We don't want to relitigate it.
Understand.
ALJ disagreed
Understand.
with you. We want to stay in the lane.
so again, 5 days after the agreed order was signed?
That's correct.
All right, any other questions? Okay, I'll entertain a motion.
I move that we adopt the PFD as written on my side.
Is there a second to that?
I'll second.
All right, discussion? All right, all in favor say aye.
Aye.
Opposed? Motion carries. Thank you, Mr. Bruce.
What are we doing on Allied?
We're not gonna comment. This one we've got an agreed upon.
Right.
So, we got, Allied Collision Center. This one, enforcement has an agreement with, the company, so I just need a motion to dismiss the PFD.
I'll make the motion.
Second? All in favor say aye.
Aye.
Carries. Thank you, sir. Thielen, good to see you.
Thank you. You too.
All right, you, Miss Zulu?
I think it's
Give me
Hui
that.
Zulu,
Wee Zulu.
and I don't see her attorney here.
Okay, all right. Thank you, Mr. Thielen, for that.
Good morning, Commissioners. My name is Trevor Thielen. I'm a prosecutor with enforcement. I handled this case at SOA. We recommend that you accept the administrative law judge's PFD and revoke Hui Zulu's massage therapist license and deny her renewal application. The facts are undisputed. In 2003, Ms. Liu pled either guilty or nolo contendere to prostitution, and the Collin County Court at Law No. 4 placed her on deferred adjudication for 9 months. She completed that probation, was discharged in 2004. On May 30th, 2013, she applied for a massage therapist license from the Department of State Health Services, DSHS, who regulated the massage industry at that time. DSHS renewed her license twice, in 2014 and again in 2016. Then, in 2017, the legislature transferred the massage program to TDLR. When Ms. Liu again renewed in 2018, we discovered the prostitution deferred adjudication and tried to figure out how to properly apply the massage laws to these facts. The proper application of the law to these facts is what will determine the outcome of this case. TDLR then opened this case because we concluded that Ms. Liu was never eligible for her license in the first place, that it was unlawful for DSHS to grant her that license, that it is unlawful for you to renew that license, and that the law requires you to now revoke that license. This is admittedly a strict outcome for Ms. Liu, but that strict outcome is what the law requires of us and of you. The laws we're dealing with today are Texas Occupations Code sections 455, 152A, and 455, 251B1. 152A states a person is not eligible for a license as a massage therapist if the person is an individual and has been convicted of, entered a plea of nolo contendere, or guilty to, or received deferred adjudication for an offense under, and one of the options is subchapter A, chapter 43 Penal Code, or another sexual offense. Prostitution is one of the offenses located in subchapter A, chapter 43 of the Penal Code. And Ms. Liu unquestionably pled either nolo contendere or guilty to that offense and was placed on deferred adjudication for it. The second law, 251B1, states that the commission or executive director shall revoke the license of a person licensed as a massage therapist if the person is convicted of, enters a plea of nolo contendere, or guilty to, or receives deferred adjudication for an offense involving prostitution or another sexual offense. Ms. Liu also clearly fits these categories. The ALJ requested and received extensive briefing from both parties on the meaning and proper application of these statutes. In the PFD, the ALJ considered and rejected Ms. Liu's arguments and found that the plain language of both statutes required denial and revocation. At your last meeting, you considered the very similar facts of Lisette Martinez, who received deferred adjudication for prostitution in 2009 and got a massage therapist license 2 months later. You agreed that, with that ALJ, that you were required to revoke that license and deny that renewal application. The law requires you to apply those same standards to Ms. Liu. It requires you to revoke her license and deny her renewal. You can do so by adopting the PFD as written. Are there any questions I can answer?
Any questions, Mr. Thielen? Here. Hey, Brad, these fact-finding amendments, is that part of the modification of the PFD that you had mentioned on number 1 and number 8? Or is that just technical?
Yes, Mr. Chairman, those are technical corrections.
Okay.
It has to do with, let's see.
I read them as technical. I want to make sure I'm not misinterpreting.
Yes, the license, the massage therapist license number is incorrect in finding of fact number 1, and then the date of the hearing that's referred to in finding of fact number 8.
Okay. Just, Commissioners, what that means, basically, just in PFD. We're going to decide it. Any comments? Mr. Thielen?
No.
Okay. Motion?
Well, I move we accept and adopt the PFD as written with the modifications as, for fact number 1 and 8.
Okay.
Second.
Any discussion? All in favor, say aye.
Aye.
Opposed? Thank you, Mr. Thielen. Mr. Bleem. Anybody from Mr. Bleem here? Okay. Mr. Thielen.
My name is Trevor Thielen, still prosecutor with the Enforcement Division. I also handled these 2 cases at SOA, which were tried in a single hearing. We recommend that you accept the administrative law judge's proposal for decision after making one slight change, which will not alter the judge's recommendation that you revoke Christopher Bleem's consent tow operator license and deny his incident management tow operator license application. Between 2010 and 2015, Mr. Bleem was convicted of 4 misdemeanor offenses: theft, assault, family violence, terroristic threat, and possession of marijuana. In 2016, he applied for a consent tow license. We took a chance on him and issued the license. The consent license expired in 2017. In May and June of 2018, Mr. Bleem pled guilty to 2 additional offenses. First, he pled guilty to credit card abuse, which is normally a felony but can be treated as a misdemeanor if the state agrees, as it did in Mr. Bleem's case. At the hearing, Mr. Bleem claimed he was not guilty of this offense, despite the fact that in criminal court, he pled guilty to possessing and intending to use a credit card which belonged to a woman who had used it to pay for her impounded vehicle without the woman's consent. He served a 72-day jail sentence for this offense. The second offense Mr. Bleem pled guilty to was a felony, assault family violence by strangulation. The victim, Mr. Bleem's girlfriend, told police that while the two were in bed together, Mr. Bleem suddenly and angrily confronted her about a photo he found in her phone. She said he slapped her in the face several times and then got on top of her and choked her to the point where she thought she was going to die. She said she fended him off enough to stop the choking and deflect some of the strikes, but then Mr. Bleem grabbed her by the neck and slammed her head into the wall. After she called police, who saw visible abrasions on her hands, arms, neck, and shoulders, as well as a broken bed frame and a large black mark on the wall, Mr. Bleem told them the two of them had just been wrestling. The court placed Mr. Bleem on deferred adjudication probation for 8 years. He's completed 1 year and 4 months of that so far. In August of 2018, Mr. Bleem applied for an instant management tow license. The application required him to disclose all of his criminal history, but he denied having any, even though it had been less than 3 months since his conviction for credit card abuse and less than 2 since he went to court on his felony assault. He gave no reason for the false answer at the hearing. Mr. Bleem offered no letters of recommendation either. The ALJ considered all the statutory factors and determined that the assault offense was too recent and too serious for the applicant to be trusted again with a tow license. She also found that all of the offenses were directly related to the towing occupation, and that the false answer to the criminal history question could also justify denying the IM tow application. In the end, she recommended you deny the application and revoke the expired consent tow license. We agree with almost everything that ALJ wrote, but take sincere issue with one important section of her PFD. In footnote 4 on page 2, ALJ Bierman found that it was improper for TDLR to base a license denial or revocation on lacking sufficient honesty, trustworthiness, and integrity for the license through Texas Occupations Code, section 514012A. In only 2 sentences, the ALJ waved away a power which the Commission has used regularly since it was created in 2010, most recently at your meeting last month. The ALJ did not address that or the fact that at least 20 different ALJs, including Judge Bierman herself in another case, have found it proper for the Commission to use this power. This issue was never raised by Mr. Bleem, and the ALJ didn't mention it before issuing her PFD. Unfortunately, when I first reviewed the PFD, I missed this important footnote. I didn't see it until after the time for filing exceptions had expired, and I had lost my opportunity to try to change the ALJ's mind through exceptions. Enforcement is fully prepared to fully engage in that legal debate the next time it comes up, but that will have to happen in another case. But because the ALJ based her recommendation of denial and revocation entirely on different Commission powers, you can preserve this issue for discussion in a separate case by abandoning only the language in footnote 4 on page 2, but otherwise adopting the PFD as written. That is enforcement's recommendation. Are there any questions that I can answer?
Thank you, Mr. Steele. Any questions? Entertain a motion.
Yeah, I move that we adopt the PFD, but do we need to reference in referencing the staff side? I think you. Yes, I have that. Adopt the PFD as written, except for the footnote that Mr. Thank you. As written, except for the footnote on footnote 4 on page 2, which should be abandoned.
Is there a second?
Second.
Any discussion?
None.
All in favor?
Aye.
Motion carries. Thank you, Mr. Steele.
Thanks, Trevor.
All right, we have motions for rehearing. Read this to you real quick. If you're here today for a motion for rehearing, you wish to speak to commission, we will call you up when you announce your case. We'll hear from the general counsel first, and we'll have the opportunity to speak. Make sure you fill out the public comment form if you want to speak and turn that in to Ms. Fletcher. Make sure you speak in the microphone, say your name and who you represent. This is a motion for rehearing, which means they already have been the decision made in your case. We're not here today to re-argue the case. I can't say that enough. and this is an opportunity for you to tell us how we've made an error in entering the decision against you. And you will be limited to speaking about those issues that you raised in your motion for rehearing, okay? And I don't think we have anybody from Pravat.
Okay. Not aware.
Good morning, sir.
Good morning. Thank you, Chairman, Commissioners. Doug Jennings, Assistant General Counsel for the Department. We have one motion for rehearing for you this morning. In the matter of Darian Pravat, or Prevost, I'm sorry, I'm not sure how it's pronounced, this matter resulted from a default order in which the Department assessed administrative penalties against the respondent in the amount of $7,000, and that was based on the respondent allegedly offering to perform and then performing air conditioning and refrigeration work without holding the required ACR license, contractor license. Just a couple of points in the motion for rehearing. The first point that respondent makes, well, he contests the Department's allegation that he engaged in ACR contracting. He states that he did not perform work at the house in question, as outlined in the NOAV. However, an overview or a review of legal files shows that I've reviewed the notes of the assigned investigator and other documents, and it seems that those allegations were supported. So there is no merit to that point. Additionally, the respondent states that he spoke with Enforcement Division staff, and the staff offered to settle the case for 50% of the original administrative penalty amount if the respondent would remove his online advertisements. Reviewing the call logs and email logs, no such communication took place. It appears that enforcement staff gave the respondent 1 week to respond with documentation showing that he had removed certain ads from a number of websites, and there's no indication that the respondent ever contacted the department or provided any documentation to the department via phone, via email, anything. So we also believe that that point is without merit. And so we would recommend denial of this motion for rehearing.
Thank you, Mr. Jennings. Appreciate it.
Oh,
Any
thank you.
comments? Questions? Motion?
I move that we deny them for rehearing.
Second.
All in favor, say aye.
Aye.
Opposed, carried. Thank you, Mr.
Thank you.
All right, I think that's it, Tamela? There's motions for hearing. Have I missed anything? Okay, on to rules. Item L.
Good morning, Mr. Chairman, Commissioners. My name is Derek Burkhalter. I'm an Assistant General Counsel with TDLR.
You new?
I have been here about a year and a half.
Year and a half? Sorry.
So
okay.
fairly new. I've been before the Commission once before.
Okay.
So today I'm here to present item L to you. This is a new rule that we're proposing. It implements Senate Bill 1200. And SB 1200 authorizes a military spouse to engage in a business or occupation for which a license is required without obtaining the applicable license if the military spouse is currently licensed in good standing by another jurisdiction that has licensing requirements that are substantially equivalent to the requirements in Texas. This authority lasts only for the period during which the military service member to whom the military spouse is married is stationed at a military installation in Texas, but not to exceed 3 years. SB 1200 also authorizes a licensing agency to issue a license to a military spouse who meets these requirements. And again, that license cannot exceed a 3-year period. So SB 1200 added a new section to the Occupations Code. It applies to all agencies who issue licenses subject to the Occupations Code. We have proposed a new rule to our Chapter 60 rules of procedural rules of the Commission and the Department. Essentially what our rule does by implementing SB 1200 is it says a military spouse living in Texas who meets the requirements has to provide the department with documentation showing that they are licensed in good standing in the other jurisdiction. Also their proof of residence and their military ID card. And once the department receives that, we will issue them a letter confirming that we have confirmed that they are licensed in that other jurisdiction. That other jurisdiction does have licensing requirements substantially equivalent to ours. And then the spouse can use that letter to engage in the license practice in Texas. Now, if they undergo an additional step and undergo a criminal history background check, then we will also issue a license to that military spouse. This rule was published in the Texas Register on October 4th. The comment period closed yesterday. We received 11 comments, and thankfully we did not receive 1,000 of them last night. Just to generally summarize some of the issues raised in the comments. One comment was in favor of the proposed rule. Some of the comments that were in opposition, just to kind of summarize for you, some of the comments were concerned that this rule allows people to perform work in Texas that does not meet Texas standards. The point that comment misses is that these spouses who are practicing will still be subject to the regular laws and regulations applicable to that license type. And so it's not just a free-for-all, we still have regulatory authority over them. Some other concerns raised were that this is allowing people to, that it's not fair to our existing license holders that these people are not subject to the same requirements. And the point to address that is that these people are subject to similar requirements, just in other jurisdictions. So they're going to be subject to the same types of licensing requirements, educational requirements, experience, et cetera. Those are just the requirements of the other jurisdiction that we are checking to ensure are substantially equivalent to ours.
And that comment, if I may, was made from military spouse, right, versus civilian. Is that particular comment? In relation to the statements you just
that was
made?
an issue raised by a few different comments. There was a comment questioning whether this only applied to military or whether it would also apply to civilian. It only applies to military spouses, that is, individuals who are married to a military service member who is stationed in a military installation in Texas. So the individual herself, or his or herself, may be a civilian in their personal capacity, but they would be married to a military service member. I don't know if that addresses your question.
I mean, read again what your consensus statement was.
The summary statement
Right, summary statement.
was that the commenters felt that it was unfair to existing license holders to have other people come into the state and not be subject to the same licensing requirements. And the response is that they are subject to similar licensing requirements of other jurisdictions that we have verified. And so it's not that they necessarily have an advantage, it's just that their requirements exist in another jurisdiction.
Commissioners, Brian Francis, as we worked with the author of this bill throughout the legislative session, the one thing that was very obvious to our agency is we are already doing these things.
Right.
The change is that it would have a 3-year license for individuals or a 3-year ability for that person to practice. We were the agency that really encouraged the legislature to ensure that they had a piece of paper called a license so that when the military service person moved to another state, that spouse would be able to say, yes, I was licensed in Texas, and now I can get reciprocity or substantial equivalence there. That was the important part. But in terms of, in the black box, the same process that we've applied for military spouses, as well as just out-of-state licensees that have substantial equivalence, we're going to apply here. There's no, as Derek said, there's no advantage gained or lost. It's our same process. We just wanted to make sure that they had the ability to continue to carry forward afterwards.
It's a great bill. It's a great bill. Any comments?
I had a question on the criminal background check.
Yes.
Did I understand it right? If they provide the documentation that they're licensed in that other state, we don't do a criminal background check unless they want to, I thought you said something about a second part, that then we'll do a background check, but we don't do it, if they provide all the documentation, we don't do it.
So the way we have it set up, it essentially carves out 2 options. One is the first option where they're just issued a confirmation letter. That option does not require a criminal history background check. They receive a letter stating the department has confirmed that you are licensed in good standing in this other jurisdiction and you are confirmed to engage in that practice in Texas. Now, if they want to apply for this the second path is a 3-year license or a license up to 3 years. If they want to go that route, then they would have to undergo the criminal history background check to receive the actual license itself, as opposed to just the confirmation letter.
Do we feel that's I mean, I guess I'm thinking, you know, if they have a 3-year license or something and they come to Texas and they've committed some kind of offense, shouldn't we look at that?
Well, when you, again, Brian Francis, Commissioner Wesson, remember that the overwhelming majority of our licenses have a criminal background check that is done by name and date of birth here in Texas. So those individuals that could be coming from out of state, they're not going to have the FBI
So we
background
just do it
check,
for
so
Texas?
you wouldn't catch that
Okay.
part. But they also have to be truthful in their application, as you've seen today, in identifying if there's any criminal convictions they've had. And I think you've witnessed the doggedness that Ken Sharp and Trevor Thielen have in pursuing those.
Right. Okay.
So we did have a small change to the language that was published in the Texas Register. This was not in response to any comments received. This was just something that we caught, just a small correction to subsection F, if you look at the text of the rules. We have added a comma after the word license, just to fix a grammatical error, to close a little subpart of the sentence, and then we've added the word subsection to address the subsection G and H that are referenced in subsection F. So just those two small corrections, the addition of the comma and the addition of the word subsections. But it doesn't affect the substance or the meaning of the rule. It just provides clarity and consistency with the grammar of the other rules in that subchapter.
Good catch.
Thank you, thank you. So with that, I'm happy to answer any questions you may have.
Any other questions? I need a motion.
I move that we adopt the rulings as presented, in addition, you know, to making the noted 2 corrections to provide clarity and consistency.
I'll second.
All in favor, say aye.
Aye. Mr. Chairman, I'm sorry, the effective date of we wanted to get that in the commission's decision, and that would be December 1st of 2019.
Do you mind restating here? You want to imply that, you get that effective date at the motion? Is that what you're saying?
Yes, if that could be a part of the commission's.
Sure, so I make the motion that we accept the rulings as presented, along with the 2 corrections to provide clarity and consistency with an effective date of December 1st, 2019.
Everybody agreed with that second?
I'll second.
I agree. Okay. All in favor, say aye.
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 Opposed? Thank you, Mr. Burko.
Thank you very much.
Item M. Same date for this one?
Let me double check, I believe so.
Morning.
Good morning. Elizabeth Salinas, Strit Matter. I am presenting to you this morning the amendments for Chapter 77, which relate to service contract providers, but a small section of service contract providers, as you'll hear in a minute. So we are proposing 2 things today: an amendment to the rules which would implement changes to the statute that were made during this past legislative session, and a repeal of existing rules that are no longer applicable to the program. They've played themselves out, and we no longer need them in the statute. So more specifically, HB 4120 amends Chapter 1304 by allowing service contract providers who are automobile dealers offering service contracts on vehicles that they themselves sell to reduce the financial security deposit of $250,000 to a tiered minimum of $25,000, $50,000, or $75,000, depending on the provider's annual gross revenue in the state from the sale of service contracts in the preceding year. So this reduction in the financial security is only available to a small subset of service contract providers who meet the requirements as set forth in the change to the statute. And it's only applicable to those who are opting to choose to demonstrate financial security during the licensure process by utilizing the funded reserve and financial security deposit option available under Chapter 1304. The proposed amendments and the repeal were published in the Texas Register on August 30th of 2019. The public comment closed on September 30th, 2019. We received one comment from the Texas Independent Automobile Dealers Association. They expressed support in the amendments that were proposed. There were no comments received on the appeal to the existing rule of 77.44. And we recommend adopting the proposed amendment and the repeal without any further changes. And the effective date is December 1 of 2019.
December 1 as well.
Yes.
Is there any comment?
I think it's a good bill. Good rulings.
A question, who holds those funds?
It depends. They're all held outside of the agency, but they have to provide instruments of financial security to us, or they have to provide their letter if they're opting to show us. Hang on one second.
It's a bond, basically, is it effective?
It could be a security deposit.
It's a security deposit,
So it's
a
not a
bond.
bond, it's an actual security deposit.
It's
at
a
an
security
institution.
deposit. They have to actually hold a balance and show us proof of the balance. They have to show us an instrument from a financial institution showing that they have that amount of money in their account, or they can actually do a certificate of deposit.
Do we template that account, or do we, it's just an account that's in their name and is unrestricted?
If it's the account, they'll provide, Brian Francis, they'll provide their financial statements, and we will evaluate their funded reserve, which is maintained on their balance sheet. It's the basically recognizing the income as it's earned over time.
Right.
And then subsequent to that, or in addition to that, you'll have the security deposit or the surety bond. So it's twofold. One, are you accounting for it properly? And two, are you maintaining something separate that we can tap into if something goes awry?
Right, and the amendments to Chapter 1304 do build in a reduction for those folks who fall into this restricted class of people that can reduce their $250 financial security. There are methods built into the bill for reducing the amount that they currently have on record for their financial security. They can draw it down over time using the CD, or they can draw it down immediately if they have cash on hand that's in a bank account, or they can get their financial institution to reissue a financial institute showing the new minimums that they're required to hold.
And I'm just on the bond issue, right? There's a bond. There's some sort of somebody liable. This one is an institute, is an account. If somebody they show us that account, then they draw down that account the next day. That's what I'm asking, I guess. Is there
No,
a
there
restricted
is a
template?
separate document. There's a separate financial device that we can tap into. It is separate from what's happening on
So
their
it's
balance
template.
sheet.
There's a template on
Yes.
it. We call it
We keep
template.
we keep it on file here.
Right, so
Yes.
we template okay, that's all.
Yes.
And it is assigned to us as well.
Right.
And that's, all institutions have those. I just want to make sure which structure that is.
Yes.
Okay. Any comments, any other comments?
Yeah, no comments.
A motion?
Make a motion to adopt the proposed amendments, and along with the proposed repeal, removes that with the outdated provisions, and with the effective date of December
December 1.
1, 2019.
I'll second.
All in favor?
Aye.
All right.
Opposed? Carries. I'm looking for the curveball, Brad. I saw I was looking for the curveball. You always throw me a curveball.
It's all good.
Mr. Chairman, Brian Francis, Doug is coming to the table. The last two presentations you had on rulemaking, that's the first of many that will come to you pursuant to our bill implementation process. And I just want to commend the staff for being so quick to have the bills effective on September 1 and have rules ready for adoption in front of you, which means they've gone through the proper advisory boards, et cetera. To have them here is just a great effort on our team's part, so I
No,
appreciate it.
exceptional time.
Yeah.
You guys, great turnaround.
Great job.
Mr. Jennings?
Thank you. Doug Jennings, Assistant General Counsel for the Department. Thank you, Chairman, Commissioners. We have before us a proposed amendment to Rule 7320 regarding the electricians program. And what this amendment does, this is not bill implementation, by the way. This is a staff and industry-driven amendment. We had, I believe in the beginning of this year, we had some summits with board members, members of the public, with the goal to better understanding paths to licensure. I'd say that's pretty broad. And so what this amendment does is removes the artificial restriction that's in the current rules, limiting a person to claiming 2,000 hours of on-the-job experience in a given year. So for background, certain electrical licenses require an applicant to prove X number of hours to obtain that license of on-the-job experience. For example, a journeyman an applicant for a journeyman license must prove 8,000 hours. An applicant for a master electrician license must prove 12,000. So under the current rule that a person is limited to claiming up to 2,000 hours in a given year, this would remove that restriction. The proposed rules were published in the Texas Register on July 26th, and the public comment period closed on August 26th. We got several comments. We got 38 comments actually on this one, and I'd say they were, among the responsive comments, I would say they were split into three camps fairly evenly. One was clear support for the proposed rule. One was clear opposition, and then the other grouping suggested that rather than removing the restriction altogether, that we replace it with a higher number. For example, an applicant should only be able to use or claim 2,500 hours, for example, and some of those, I think the range was 2,360 up to, I think, something like 5,800 hours. We took the proposed rule after publication and comments. We took that to the Electrical Safety and Licensing Advisory Board on September 26th. And that board recommended adopting the proposed rules without change. And so the department recommends the commission adopt the proposed rules without changes as recommended by the advisory board. And again, that would be an effective date of December 1. Happy to answer any questions.
Mr. Chairman, Brian Francis, this is one in a number of steps that we're going to bring to the commission to help us address some of the issues dealing with the shortage of the folks in the electrician's trade. We all know that the amount of work that's being done, whether it was a result of Harvey or just Texas in itself, that folks are working overtime in this area, and we were artificially stopping them from applying the experience in those hours towards getting their license. This is going to allow somebody who's been doing 4,000 hours of work or 3,000 hours of work to get to that next level sooner. The other provisions that we're going to be looking at is allowing folks to take the examination a little bit earlier, but we wanted to bring these incrementally so we can evaluate the benefit. What's the impact of making this change? What's the impact of making the next change? And should we take a third change? So this is something that we've discussed probably over the last year and a half.
Thank you, Brian.
And we just need to keep an eye on this because this can be abused, right? I mean, once you open that unlimited, I mean, somebody has 16,000 hours, right? I mean, just
We'll definitely take an eye
Yes.
on it. And our process today requires that the master electrician, that they earn the hours, certify that. So it's not the person saying, this is what I've done.
Right.
But our current process uses the merit and basically the veracity of those master electricians and the companies. We also, with our licensing division, will gather additional information to confirm that as well.
And just to add, thank you, Brian, because a licensed contractor is required to sign off on these hours, or a licensee is required to sign off on these hours, a person who submits a false report or a false verification is subject to sanction, including and up to revocation.
good. We'll need it. We need them. We need them. All right. Okay. Motion.
I'll move to adopt the proposed amendments effective as of December 1st, 2019.
Is there a second?
Second.
Discussion? All in favor, say aye. Opposed?
Thank you.
Mr. James. All right, item O.
And if I may, Mr. Chairman, before we get started with item O, so Brian, I know that, some of the comments, talked about, yes, if you go with, the motion that was just moved about the exam scores being at a higher level. I mean, how do you see that, in which direction with?
In the conversations that we've had, the summit, there was a position offered that the sooner the person can take the examination in proximity to the hours that they're earning and experience they're earning, the closer they're going to be to that knowledge, and maybe they'll do better on the examinations. We're going to test that. We're going to see if these folks are getting approved with their hours sooner, if the exam pass rate changes. That's also part of the apprenticeship programs, having the theory part of their courses early on, but they're not taking the examination until after, well down the road. We're going to test those and continue to do what we can to help qualified individuals get into the business sooner.
Sure. And the passing grade is?
It's extremely low. I mean, it's always hovered below 35%, but part of it is that these individuals have to know how to do the calculation, they have to know how to navigate
Right.
the National Electrical Code. We're not going to let them, turn them loose on someone's home, their business, and have those things go up in smoke.
Sure. Thanks.
Good morning. My name is Mark Gladney with the General Counsel's Office. I'm here to present amendments to existing rules at 16 Texas Administrative Code, Chapter 66, specifically 6620, 21, 6625, 6670, and 80 regarding the Property Tax Consultants Program. The rules under 16 Texas Administrative Code, Chapter 66, implement Texas Occupations Code, Chapter 1152, related to property tax consultants. The proposed amendments clarify registration requirements. They extend the renewal license term from 1 year to 2 years to comply with existing statutory language in 1152.202. Increase the number of continuing education hours from 12 to 24 hours, which would start for licenses expiring May 1st of 2021, and they reduce registration fees from $150 to $135 for renewal licenses. The proposed rules were published in the Texas Register on July 12th of this year. The public comment period closed on August 12th. The department received 1 comment during the 30-day comment period. The Property Tax Consultants Advisory Council met on these rules on September 19th to discuss them, and the 1 public comment received. The Advisory Council recommended adopting the proposed rules without changes, and staff recommends that you adopt the proposed rules without changes with an effective date of December 1st.
Thank you, sir. Any comments, questions?
Yeah, so $135 for reduction in the fee, get that, extension of 1 to 2 years, great. But increasing the number of continuing education hours from 12 to 24.
It was just matching the time period. For the 1-year license they had, it was 12 hours, moving it to 2-year
Okay, so
license.
same cost.
It just
There's no additional, they're paying for it, though.
Same annual increment.
Okay, all right, that's what I wanted to clarify.
And I'd also like to note that there's a change in the allocation of the 24 hours. Previously, it would have been only 3 hours of instruction on Texas law and rules. With the change of 24 hours, it's gone up to 8 hours of instruction on Texas state law, and they also increased the number of instruction on ethics from 1 hour to 4 hours. The advisory board was strongly in support of both of those changes in the allocation.
Okay, okay.
Mark, thank you. That's good.
Yeah.
Any other comments?
So make a motion, Mr. Chair, to propose the acceptance of amendments as written.
Second.
Do we have a date on this, Brad?
It's also
December 1st.
With effective date of December 1st, 2019. Thank you.
Second.
Any comments? All in favor, say aye.
Aye.
Motion carries. Thank you. All right, item P, I just wanted to reinforce that we were assigned a work group. I know that we have some commissioners that are out, but if you have any questions or if you want to be moved or if there's any particular workforce or work group that you want to work with or advisory board, please let me know. Tamala, you have a copy of those, and we want to make sure that we stay as active as possible in those things, because as you can see, we're going to be drinking out of a fire hose. And these advisory boards are our eyes and ears, because we can't be everywhere. So I appreciate y'all's time on that. Okay. Any comments about that? All right. Staff reports.
Mr. Chairman, I just want to highlight 2 things out of my report. I'm going to put my resident genius on the spot and ask Eric Beverly to come to the table. Eric is leading our efforts in regard to Sunset, and Eric's team with Eric, Jeff, Julianne Hemet, Tony Cuvion, Colleen, and David have done an incredible job of navigating us through the month of October, and we know that Sunset has reminded us they'll be with us through May, and we understand that completely, but I just want to thank the team for their efforts. Have Eric just quickly go through the conversations that we had this last month, the meetings. I also want to commend Commissioner Collier in her role of being the chair of the Sunset Work Group. She's diving in with both feet, as only Commissioner Collier can. And she's into the details and really allowing us to sharpen our approach in this review. And then finally, there was one other thing I wanted to bring up, but Eric, we'll let you just do a quick overview, and thank you for being spontaneous.
Of course. Yes, sir.
Eric, you look like you're prematurely aging, so hang in there.
Okay, thank you. Thank you. I'll do my best.
You can sit over here if you want. I mean, you get better.
Thank you for what you're doing. Thank you.
Thank
Yeah,
you.
it's huge.
Thank
We
you.
appreciate it.
For the record, my name is Eric Beverly, Government Relations Officer here at TDLR. We've had a busy October. We had 16 meetings with Sunset or related to Sunset, including an introductory meeting, a general overview meeting, and then a series of follow-up meetings that looked at different divisions within the agency, and then a series of 4 meetings that were related to the programs that are under review. So we took about 6 or 7 different programs in each meeting, had a really good discussion about each of those programs, barriers, challenges, things that are working well, things that aren't. In addition, I believe on the 31st, yes, we concluded with the Commission and Advisory Board overview meeting. And as we roll into November, we know that we will be receiving information requests, and we will do our best to get that information back to Sunset staff. And we can anticipate additional meetings as we continue to roll through the Sunset review.
Eric, I really appreciate the amount of time. The quality and the professionalism of our presentations have just been spot on, exceeding what I would expect from TDLR, so thank you.
And I want to give a big shout out to Jeff Copas. He has really done an excellent job on preparing the presentations and ensuring that they have a consistent look and feel.
Any comments for Eric?
I think, just riding it right along, with excellence. And so I appreciate yesterday, the time that you spent.
Thank you for your time.
With answering questions and, next steps, because we like to crash the board, right? We like to crash the board. So I appreciate that.
Thank you.
Only Commissioner Collier can say that, crashing the board.
Yeah, and I thought about that. I thought Carly was going to say something, but I'm allowed.
I'm not sure what that means.
That's okay.
As a recovering auditor on process improvements.
Basketball.
I appreciate your efforts on this, so thank you so much for doing that. And we welcome this. I mean, I know commissioners, we've never been, this thing's, so this is, we're flying the plane and building on, discovering we want this. This is great for us.
Yes,
So
it is.
thank
It's
you.
a wonderful process.
It is.
Thank you, Chairman.
All right.
Thank you.
Mr. Francis, anything else?
Mr. Chairman, I'd also like, under my report, for Brad to give an update on consumers from the Auctioneer Education Recovery Fund, and then Mike's just going to do a brief update on where we are in motor fuels.
Mr. Chairman, Brad Bowman, General Counsel. This is just a quick update for you on there were a number of cases against an auctioneer, Vern Wallace. There was one case that came to the commission a little over a year ago. And we've been kind of providing you updates on this as it's gone along. We don't have complete closure yet, but we're very close to closure on that. There were a total of 23 cases, claimants that had been harmed by the actions of this particular person, and there were payments. Well, first of all, the Enforcement Division had to take all of those cases through the process and get final orders to order payment from the Auctioneer Education Recovery Fund for those consumers. Unfortunately, there's a $30,000 cap. The total amount of claims far exceeded that, so each claimant, we were only able to pay about 30 cents on the dollar. But those payments have been, for 19 of them, we paid out a total of a little over $29,000, so almost up to that cap. There's one that's in process, and there are 3 that are still outstanding. They're small amounts, and we just haven't heard back from those particular claimants with the information that we need. But those are all in progress, so we hope to have complete closure on this very soon. So I just wanted to update you on the department's progress on those matters.
Is there any lessons learned from this that we could take away? I'd like to get that, because 30 cents on the dollar is not something I would say is something we should shoot for. And I don't know if it's to up the fund or to figure out what we need to do and discuss that this doesn't happen again.
And that is a statutory cap. And unfortunately, when we have, and they're very rare, but when we do have situations like this, that can be an issue, that we're just not able statutorily to reimburse the consumers the full amount that they're owed. Now each consumer does have a final order from TDLR.
Right.
And so if they want to go to court and exercise their civil remedies, they do have some support there, and so we were able to help them in that way also.
Thank you.
Any
Brad, thank you.
comments? Mr. Boone?
No comments. I mean, no comments.
Okay.
Thank you.
All right.
Chairman, Commissioners, Mike
Who are
Erisman
you?
is Deputy Executive Director. I just thought I'd introduce myself to you. I'll be brief. I know I stand between you and lunch. So just wanted to kind of give you a quick update on the motor fuels program that we have begun the transition over to TDLR. Just kind of FYI, we're in the process of moving pieces of it over as we can beginning September 1, excuse me, of 2020 is when we have full authority over the motor fuels program. So I do want to have you keep that date in mind, because through the course of this next fiscal year, we begin to be giving you updates as to where we're at as we're bringing and transitioning it over to us. So we're working through some issues, but I think we're getting there. We continue to work with the employees at TDA. They have been fantastic in helping us out and working through some of the issues that we've had. I do want to real quickly note that we currently have positions open for the motor fuels program in order to transition it over. As you're aware, we believe we had 68 FTEs that were assigned to us for the motor fuels program, so we're beginning to start filling those positions. Currently, we do have some employees that are with us. We have Tim and Jonathan and Richard that are sitting right here that are with the motor fuels program, and we've had positions open in field inspections and RPM and enforcement. And what we found out that every single one of them could apply for every single position because they could fill every one that we had open. So they've been a great help for us. Jonathan and Richard just came on board, I believe it was this week. And so they've just started with us. But we know that they bring a lot of knowledge of the program. We also have Jessica Escobar, who's in the back. She's in our general counsel. She actually was instrumental in having a lot of legislation written for motor fuels and the skimmers program. So we are bringing over a lot of knowledge from the Texas Department of Agriculture and this program. We look forward to continuing to take it and ramping up and just kind of shining above as we always do. So it's a real quick, brief update on motor fuels.
Well, gentlemen, welcome. And Jessica, welcome. You're working with Mike, so use small words. He went to Texas Tech. So, and big words confuse him. So I would, that's my advice to you, if you will. But I can tell you that there's no program. I know, only love, especially. There's no program we have that has the breadth of impact in this one. And so whatever we need to do to know the institutional knowledge, and I think that again, institutional knowledge is its strength, but it has its weakness. So how we rethink this as a whole is an opportunity now to rethink what we do, so it's just not being done the same old way. But that institutional knowledge is huge, so whatever we can do to help facilitate that, this commission is going to be fully on board. We'll make that sure happen, make it a success, especially by September.
Mr. Chairman, I'd also like to acknowledge that, in the room today, we have individuals that are in the leadership capacity for the Texas Food and Fuel Association, which is a very big player in this area, and I think it's a big statement on their part to be present and wanting to let us know that they want to engage with the agency and the commission. So we appreciate you guys being here, Paul and Scott and Matt. Thank you all.
And Mike, how do you see the team staffing up? I mean, the timeline over a period of time, or?
We actually have begun the process, as I mentioned, of hiring. We have positions open currently. They're interviewing. We hope to have everybody on board. We're anticipating by about December or January, so that we can have the full impact of what we need. This particular program, of course, we primarily see the focus being in our RPM program and also in our enforcement division. And licensing, of course, will be the full impact of where that's at, but a bulk of the knowledge will be based in the enforcement and the regulatory program and being able to ramp up in that capacity. So, but we're hoping that by December, January, we should be staffed with it.
Francis?
Mr. Chairman, that's all we have. Thank you.
No Carla James?
I asked her if she wanted to do a final report. She said no, but not like that.
All right, well, that's exciting. Thank you. Carla, again, thank you for what you've done, and thank you for your efforts. Can't echo that enough, and appreciate Francis, well done. All right, any other comments from the commission? All right, no. All right, we have a date that is December 10th, is that right, Tamla?
Correct.
December 10th will be the next meeting. I know it's a lot.
If I may, Mr. Chairman, I would like to.
Okay, go ahead.
You're okay with that? I do also want to extend a thank you to Mike and his team on yesterday as well, bringing me up to speed with the Veterans Initiative as well as prison reform. Also spoke with Mary and forget the intern's name.
Brian Cottle.
Thank you so much, Brian Cottle.
Yes.
Pertaining to trafficking. So I do appreciate that because those are, areas that I think are very important. We'll continue to keep a focus. But I would like to see prison reform as an agenda item going forward.
Excellent idea. Excellent. The prison reform, anti-human trafficking.
We'll keep them. We'll have those as part of my staff report, so I'll always be able to give you an update on this.
Right. These are all motor fuels. These are all we're willing to take on with you guys. You're not, and so Tamala will make sure and put those on the agenda to have some discussion points. I want to have that conversation out loud as much as possible because it's straight through that.
And I don't want to be remiss. Thank you, Brandy, on the hub side as well. So that's important. So I don't want to. She's like, sure.
Any other comments? December 10th is good. All right.
December 10th, yeah.
I'll entertain a motion for adjourn. Unless y'all want to hang out here for the rest of the day.
So moved.
Second.
All in favor?
Aye.
Aye.
All right. Motion carried. 11:44. Meeting adjourned.